AI Act is the world's first AI-focused legislation anywhere in the world.
I want to understand what I need to do and what my business needs to do in order to be compliant with the Act.
The first test is AI system or a general purpose AI model. The second test is, are they a provider or a deployer? Test number 3 is the output of that AI system being used in the EU.
How much time do we have to prepare and become compliant?
Honestly, not that much time.
If I was a business owner, what should I be prioritizing?
There is 4 tiers based on risk as to how the Act regulates an AI system.
What are the penalties and what happens if we are non-compliant?
Infringement of those rules could result in penalties of 7% of global group annual revenues or 35 million euro.
Hello and welcome to Beyond the Algorithm. I'm your host, Samani. I work with executives to help them understand the implications of AI on the whole business sphere, from strategy to risk and governance to culture and compliance. I talk about it a lot at conferences, at corporates, and here on this show. Today we focus on a significant regulation shaping the future of artificial intelligence, the EU AI Act. Effective from 1st of August 2024, the European Union AI Act is the first comprehensive legal framework for AI, addressing risks and ensuring that these systems respect the fundamental rights and ethical principles. Although it is a European regulation, it will impact businesses globally. Any company that designs, develops, or uses AI within the European Union will be impacted by the regulation. Supporters of the Act argue that it protects consumers and boosts innovation by establishing Europe as a leader in AI regulation. On the other hand, critics claim that it is inadequate, it lacks effective enforcement, and could stifle innovation. Like it or not, whichever side of the fence you sit on, it is here to stay. Non-compliance with the regulation will be expensive and could result in being locked out of the market. Compliance, on the other hand, requires sizable investment. Some estimates suggest a global compliance cost to be between $1.5 and $3 billion. For SMEs, depending on the risk in their AI systems, compliance costs could reach up to $400,000. That is not insignificant. This is a complex and expensive issue. So, I have invited an expert to help us unpack and understand the EU AI Act. My guest today is Vishnu Shankar, a partner at the international law firm Morgan Lewis. Vishnu brings several digital regulatory capabilities, including matters involving the EU and UK data protection, cybersecurity, and children's online privacy. Vishnu represents clients in high-stakes EU and UK privacy, cybersecurity, compliance enforcement defense, and other litigation matters. Vishnu, it is my pleasure to welcome you today. Thank you so much for taking time out of a very busy schedule to speak with us.
Arti, thank you so much for having me. It's a real pleasure to be here. I have been fortunate to get your expertise and thoughts on a variety of AI matters, and I'm delighted to be here.
Thank you and welcome. So Vishnu, let's go straight in. Tell us a little bit about your journey into the area of your work that you are and what your focus is.
Sure. As you were saying, I'm a partner in Morgan Lewis's Brussels and London offices. I focus exclusively on EU, UK privacy, cybersecurity, and AI matters. Prior to coming to the firm, I served as the head of legal regulatory enforcement at the UK Information Commissioner's Office, which many of you will know is the UK's privacy and cybersecurity regulator and equivalent to the FTC and Department of Justice cyber division in the US. So I have a mix of private sector and regulator side experience, and I try and deploy those at my clients to help find cost and risk proportionate compliance solutions. I've been extremely focused on advising many of my clients on EU AI Act matters, and I'm delighted to share some of my thoughts with you today.
Thank you. We couldn't have asked for a better informed, a better versed individual than yourself, Vishnu. So, can you walk us through the core objectives of the EU AI Act and why it is considered a game changer in the AI regulation space?
Sure. So the AI Act, as you were so rightly saying earlier, is the world's first AI-focused legislation anywhere in the world. If you're like a trendsetter, it adopts a risk-tiered approach to AI regulation. The legislators of the Act claim that it will be a good balance between regulating a powerful and yet possibly unknown technology, but also not stifling innovation. Now, the EU AI Act, it could potentially be a template for AI regulation around the world in the same way that the GDPR has been a template for many new privacy and cybersecurity laws around the world. So-called Brussels effect that made the GDPR which made the GDPR to have a global impact. The same Brussels effect could possibly also apply to the EU AI Act. So, in a sense, companies who are subject to the EU AI Act may be setting themselves up for compliance elsewhere in the world as well.
Yeah, understood. Thank you. That's very comprehensive. Now, the question is, who does the EU AI Act apply to? So, if I'm a business, especially if I'm a small or medium-sized enterprise, I want to understand what I need to do and what my business needs to do in order to be compliant with the Act. Do you have a very simple framework for our audiences that is easy to understand and they can take it away and utilize it in their business?
Absolutely. So I'm going to try and boil down what is a pretty complex jurisdictional and scope issue under the AI Act. To really boil it down, there are three questions. One, is the technology that you are designing, deploying, or using, is it going to qualify as an AI system or as a general purpose AI model? If the answer to that question is yes, then you are then one of those three jurisdictional questions has been answered.
I'm sorry, may I just interrupt you there? For our audiences, can you just help us clarify what is an AI system and a general purpose AI system?
Sure. So an AI system is a machine-based system that operates with varying degrees of autonomy, which may include adaptiveness, and is able to infer an output from the input received. Now, this is an extremely broad definition, so it's deliberately intended to capture a whole host of technologies, right? So an example of an AI system is a chat bot that's sort of like run on an algorithm. A general purpose AI model, on the other hand, is one step higher in the AI chain. So it's essentially a model that has been trained on a large amount of data and which displays significant generality and is able to perform a wide range of distinct tasks. I'll give you an example. OpenAI's GPT large language model is an example of a general purpose AI model. Now, GPT can be used in a variety of ways, and that's what makes it an AI model as opposed to an AI system. So a chatbot that runs on GPT, the chatbot is an AI system, and GPT is, as I was just saying, a general purpose AI model. So in effect, a variety of applications run on GPAI models, and those applications could be AI systems, and the model itself is a general purpose AI model. So to be in the realm of the AI Act, one needs to either be designing, operating, or using either an AI system or a general purpose AI model. So that's the first test. Now, maybe I can run through at a high level the two other tests, before I head into the weeds of each of them. So the first test is it an AI system or a general purpose AI model? The second test is the stakeholder in question, are they a provider or a deployer, or really any one of the other subcategories of stakeholders caught in the act? So that's test number two. Test number three is, um, um, as you were saying, there's a jurisdictional hook to this, right? Which is to say, is the AI system being put into service or offered in the EU market? Or more critically, is the output of that AI system being used in the EU? Now, it's the last bit that really casts a very wide net, because the output of an AI system could mean things like predictions, content recommendations, decisions, etc. And even if those outputs are generated outside the EU, say by an AI system that's hosted and run on a server in the US, but the output is used in the EU, right? So that could then trigger the application of the act. So for companies, I think, oh, I have no physical presence in the EU, I have no offices in the EU, I have no employees in the EU, and I only have, a physical presence in the US. My AI technology developed and hosted in the US, but if either by design or unexpectedly, one has a customer that uses that AI system to generate outputs in the EU, then that could trigger the application of the Act. So, in effect, the Act by design is deliberately casting a very broad net. And so I would suggest that if you, as head of a company, is in the AI space, one have a very quick discussion with your legal advisors as to if the AI Act could even apply. Now, it could be a very quick conversation, and at the end of that, everyone gets comfortable that the Act does not apply, and in that case, one can put it to bed. But equally, that initial conversation may open up the door to having, deeper and more technical conversation, and the end result may be that the Act applies to this business. Now, while that's not necessarily, a great outcome legally, one would rather know that the Act applies and start considering a compliance program than perhaps be entirely ignorant of it until a regulator or an individual or a customer starts asking uncomfortable questions.
Yeah. And that reminds me of another point. So you ran through the different aspects of the system and where, depending on which jurisdiction it is, the act may apply or not. Now, a lot of the times we use training data for these AI systems, right? Sometimes we know exactly where the training data is coming from. At other times, we do not. Also, our third-party suppliers whom we rely on to supply some parts of the system may be based in EU, even though everything about my business is outside the EU. This to me feels a very gray area. Where does the regulation sit on that? So I think I'm asking multiple questions here. So let's talk about the third party piece first. If I am relying on third party service providers for some components of my AI system, and that third party service providers is based in the European Union, but I am not, am I liable to be compliant, or should I be asking the third party service provider to provide me evidence of compliance of their services?
That's a great question. And I would think that, depending on the facts, if you have a third party supplier in the EU, that third party supplier, say, is a supplier of training data, right? Now, while the third party itself may have compliance obligations and that it will need to comply, it's well possible that at the downstream user of that data, that say using that data for training its AI model or its AI system, then that could well apply to the downstream user as well. Now, it's also important to note that the AI Act is only one part of the broader EU regulatory framework for AI. So notably, the GDPR still continues to apply with respect to personal data that originates in the EU. So, in this hypothetical, it may be that the user of that data who's outside the EU, it could be subject to both the GDPR and to the AI Act. And of course, it could also be subject to IP, especially copyright law, that's also applicable in the EU. So the long and short of it is, just because one is outside the EU, but if one is using a supplier in the EU, say a supplier of training data, that may trigger a whole bunch of EU law compliance obligations on the user of that training data. And of course, those very same obligations could also apply and will likely apply to the EU company itself.
Right. So a lot of nuances there, and therefore advisable to speak to a legal professional who can guide one through these complexities. How much time do we have to prepare and become compliant? So please talk us through some of the key dates for compliance of the Act.
Sounds good, Aarti. So, as you were saying at the start, the Act came into force on the 1st of August. So it's, in principle, the Act is in force. However, different rules in the Act come into force and become enforceable at different points in the coming few years. Now, we'll sort of discuss soon. The Act has a tiered approach to imposing obligations on AI systems and general purpose AI models. Now, there are rules that kick in less than 6 months, i.e., on the 2nd of February 2025, with respect to prohibited AI systems. So, in a sense, the rules will be here very soon. So, if one is designing or proposing to use an AI system that may qualify as being prohibited, then those rules kick in very soon. But for the majority of the AI Act rules, they only kick in starting from the summer of next year, and the bulk of the rules kick in on the 2nd of August 2026. So there's a bit more time, but honestly, not that much time. So if one is caught by the Act, and if one is either designing, implementing, or operating a so-called prohibited AI system or a higher risk AI system, then one needs to get into, compliance, planning, and implementation very soon.
Understood. Okay. What should businesses prioritize given these dates? And they are quite tight now, right? We are already towards the end of 2024. So if I was a business owner, what should I be prioritizing?
So I think the first step is really what we think about as a AI, inventory mapping phase, right? Because companies use AI in a whole bunch of areas. Companies design all kinds of systems that may well qualify as AI, right? And the definition of AI system and general purpose AI model is so broad. So the first thing is to really start thinking about an AI inventory and mapping exercise. So, it just tells you what you have across the organization. The second step is, and this is a really critical step, like in my view, the most important step in the whole AI Act compliance program, which is assessing if the Act applies, and if so, how it applies, right? Now, we discussed, briefly the AI Act jurisdictional framework. So, once a company gets comfortable working with its legal advisors that the Act applies, then one goes to the next part of his step, which is assessing in which risk tier the company's AI system or general purpose AI models fall into. Now, the Act as I mentioned earlier, is aiming to strike a balance between, ensuring effective regulation and also not stifling innovation. So, as regards AI system, there is 4 tiers based on risk as to how the Act regulates an AI system. At the top of the pyramid, in terms of the highest risk, are so-called prohibited AI systems. The next tier is high risk AI systems. Following that is a so-called transparency risk AI system. And at the very bottom, in terms of the lowest risk, are so-called minimal risk AI systems. Now, the Act really focuses on the first 2 categories, namely prohibited AI systems and high risk AI systems. And if an AI system falls into either one of those 2 categories, it is subject to the most burdensome regime under the Act. So a prohibited AI system are AI systems that deploy subliminal, manipulative, or deceptive techniques that distort behavior or exploit individuals' vulnerabilities or apply certain social scoring techniques. Now, those are really broad categories. Uh, what's a subliminal technique or a manipulative technique or a deceptive technique? So again, one needs to work with appropriate expert, a consultant, or a legal advisor to really work through whether one's AI system has qualifies as prohibited. Because if it does, effective the 2nd of February 2025, it cannot be used in the EU. The next tier of an AI system, also called high risk AI systems. Now, these AI systems are the ones that the AI Act really focuses on, and the bulk of the provisions in the Act apply to high risk AI systems. Now, again, the list of these systems is too long for us to go through, but it's at a high level an AI system that's covered by existing EU product safety legislation or has been specifically identified in the Act as relating to certain uses. So certain uses of AI systems in the educational or workplace context may well qualify as a higher risk AI system. So that's at a really high level in terms of thinking of compliance, right? So first step, AI mapping. Second is the second step is to assess if the AI Act applies, and if the AI Act applies, in which tier of regulation in the Act applies. And the third, obviously, is to design and implement a compliance program.
Thank you. Very clear, but also very complex. So this brings me to another question, a thought, which is there are many different types of products that use AI systems, right? There's, like you touched upon, chatbots, but equally on the other side of the spectrum, which is very contentious, is the biometric verification, whether it's used in a one-to-one verification scenario or in a surveillance scenario. So help us understand, how are different types of AI products impacted by the Act?
Sure. To reiterate, like any other products that you mentioned, biometric verification, identity verification, chatbots. Now, all of those, if they use personal data, and they may well use personal data, the EU GDPR will continue to be highly relevant. And there'll also be, IP issues that will also be relevant. Now, in terms of AI Act, as cost, one needs to think about as a gating question: is this even an AI system or a general purpose AI model, right? Now, some companies, they think that, oh, I have used this algorithm or this tool for the last 20 years, and while it's been modified here and there, it's been used for a long time. And so it can't possibly be AI. Now, I often have to tell them, just because it's old and of legacy origin, that does not mean that it will not qualify as an AI system and be subject to the Act. So just because it's somewhat old, that does not mean that it's not regulated by the Act. It could well be regulated by the Act. So in terms of examples that you mentioned, firstly, the key question to ask is, does the Act even apply? If the Act applies, then the question is a biometric verification system, has it qualify as a prohibited AI system? If it does, then, come the 2nd of Feb 2025, it can't be used in the EU. Equally, if it's a higher risk AI system, then it may well be lawful provided the various steps for compliance have been carried out. So in terms of the examples that you've given, Arti, a biometric verification system could qualify, either into the prohibited category or the high risk category or the transparency risk category, depending on exactly how it's used, right? So it's more likely that it'll be problematic if it's used in a consumer-facing context, in an employment context, or in an educational context. But where precisely is going to fall in that risk tiering is going to turn on the specific facts. Now, chatbots, on the other hand, again, while the same sort of analysis has to happen, in general, they are more likely to fall at the lower end of the risk tiering. So many chatbots may well qualify as being transparency risk, right? So, so outside of the two most burdensome categories. But then again, it's going to turn on the fact. So if you have a chatbot that's being used to deal with, extremely vulnerable individuals, and the like, that may well move the needle in terms of risk. But, it's going to turn on the fact.
Right. Wow. Okay. Thank you for that. Now, this brings up a really important question, one which is, again, in my mind at least, quite complex. So when we are training AI systems, it's not binary, right? There are multiple products which are integrated that become an AI system these days. It's not just one thing that we create proprietary and we create a product out of it. We are relying increasingly on products from the tech giants like Google's or Microsoft's of the world, right? So for example, if I have an internal system which is built on top of a Google product, I don't know where the Google product's training data has come from. It may have been trained on third-party models. It may have been trained on some of their proprietary models, etc. So how does the EU AI Act handle cases where these multiple systems are integrated? And as a business owner or as an executive in a business, how do I navigate these complexities when assessing the regulatory obligations?
Sure. So it's, as you quite rightly note, it's not a straightforward answer. In practice, you end up with, multiple products developed by different companies all being integrated. So the AI Act has this distinction between so-called providers and deployers. Now, at a high level, a provider is the company that designs and develops an AI system, and a provider is the company that uses an AI system that's been developed by this provider. Now, in a multi-stakeholder integration environment, it's possible that you have multiple providers and multiple deployers. And so, there's a downstream provider, downstream deployer, and downstream provider as well. And the Act provides for a set of obligations between the upstream and downstream party and between the upstream, between a provider and a deployer. Now, in that sort of ecosystem, one has to carry out, a careful analysis to work out who's the provider and who is the deployer. And also important to note that analysis could change over time. So initially, you have a party that simply uses an off-the-shelf chatbot created by a provider. Now, in that case, it could be quite clear that the chatbot developer as a provider and the company that's just use it off the shelf is a employer, right? And the bulk of the obligations apply to providers. So ideally, a company compliance risk perspective, at least, it's more advantageous to be a employer than to be a provider. But if in this hypothetical, employer heavily customizes this chatbot created by the provider, and customization happens in terms of branding or in terms of AI training, et cetera, et cetera. And that could well flip that employer status from being a deployer into becoming a provider, right? And so if a company has not set itself up to satisfy the obligations of being a provider, then it'll be in an uncomfortable spot when that flip happens. So, in short, I think the question you raise is a really important one. And as one integrates and applies, multiple third-party products, one needs to be very clear, contractually and in terms of the legal analysis, what role each of the companies in that product ecosystem play. Are they providers? Are they deployers? Are they, in an upstream capacity or in a downstream capacity?
Right. Okay. Now, what happens if a business is non-compliant? So no business will ever go out and explicitly say, I refuse to comply with the act, but it could be for legitimate reasons. Given the complexity, either it's an oversight or there has not been enough time to make the changes, to make the required changes for the system. What are the penalties, and what happens if we are non-compliant?
Firstly, in terms of how I advise my clients, it's a case of balancing enforcement risk and the costs, and then focusing on the most impactful risk. So, I serve on the enforcement side at the ICO. So, I try and think about like what are the key risks that a regulator would really care about, right? And what are the risks that would actually impact human beings? So to try and find the a balance for companies that helps them have a successful business, because you don't want compliance and regulation to kill innovation. Now, having said that, the act, aims to take a robust view with respect to penalties and fines and all of that. Obviously, we haven't yet had any enforcement action to date because the first meaningful rules kick in on the 2nd of February 2025, and they apply to prohibited AI systems. Now, an infringement of those rules could result in penalties of 7% of global group annual revenues or 35 million euro. And then there are sort of like lower penalties for other types of infringements, so 3% of global group annual revenue or 15 million euro, whichever is greater, for most other types of AI Act infringements, including for high risk AI system legal infringements. Now, like the GDPR, the AI Act allows for parental liability, so essentially piercing the corporate veil and potentially allowing regulators to bring enforcement action against parent companies for infringements committed by their affiliates. Now, and none of this has happened in an EU AI Act context as yet, but it possibly creates a risk for corporate group parent companies and private equity sponsors and venture capital sponsors. But overall, I would have companies think carefully about a cost and risk proportionate compliance solution.
Got it. Um, Now, cybersecurity is a big part of every business conversation right now, right? And given the rise and the level of frauds, etc., it's very, very important. So, does the EU AI Act have cybersecurity obligations as well? And if so, how do they align with some of the international standards like the NIST in the United States?
Sounds good. So yes, cybersecurity is a major issue which all of our clients grapple with almost every day, and it is a big part of my practice in terms of advising clients. In fact, just yesterday we had a cybersecurity tabletop exercise for some of our asset manager clients. And so historically, from a regulatory perspective, cybersecurity issues have been thought of from a GDPR perspective and certain EU industry-specific cybersecurity laws. Now, the AI Act, interestingly, also has a specific set of rules around maintaining information security and also reporting certain cybersecurity and other serious incidents to regulators. So the Act has obligations that apply to providers of general purpose AI models and providers of high risk AI systems to implement certain security and resilience measures. That's the key kind of obligations that apply prior to an incident taking place. Now, the Act, like the GDPR, also has reporting obligations when an incident has taken place. And these obligations apply to both providers and employers of AI systems and general purpose AI models. So depending on sort of the categorization of the AI system and the general purpose AI models, serious incidents have to be reported to appropriate governmental authorities and in certain circumstances to other relevant participants in an AI chain. So, customers may have to be informed of certain serious incidents. Now, serious incidents are also also broadly defined. So they could mean things like incidents that cause death or serious harm to a person, serious and irreversible disruption to critical infrastructure, serious harm to property or the environment, or the infringements of fundamental rights. So again, I would reiterate that the AI Act runs in parallel with other EU laws. So, for example, it runs parallel to cybersecurity incident response laws under the obligations under the GDPR. So it could well be the case that you have a reporting obligation under the AI Act, but you don't have a reporting obligation under the GDPR, or vice versa. Or you have a reporting obligation under both the AI Act and the GDPR with respect to the same incident. So, in short, the AI Act creates another layer of cybersecurity obligations under EU law. Now, the timescales for reporting are also extremely tight, and in some cases, maybe even more tight than under the GDPR. So, the most serious incidents must be reported immediately, but not later than 2 days following awareness of the same. That could be an even tighter timescale than compared to what's in the GDPR. Now, as you were alluding to, RT, governmental agencies around the world are seeking to coordinate in terms of AI security, and so the U.S. National Institute of Standards and Technology, NIST, its guidelines and its identification of AI cybersecurity risks, they're broadly are responding to the cybersecurity risk that the AI Act also considers. So, so there seems to be, at least in principle and at a high level, some alignment between governmental authorities in the US and governmental authorities in the EU.
Now, if I'm a startup or a small business, I'm I'm struggling to do a lot of things on a shoestring budget, right? And I neither have time nor do I have the budget for this at the moment. So maybe I should look at different markets in the world and sort of go outside Europe. Do you think there is a risk here that we are stifling innovation? Is the EU AI Act becoming a threat to innovation? Or is it like, let's bear the brunt now, but in the longer term, it actually fosters a more ethical and sustainable approach to AI development? Where is your thinking on this?
That's a great question, Aarti, and it's certainly so. All those had outcomes from and a societal and policy and economic perspective are all possible, but I think it's too early in the day, at least from my perch, to make a firm prediction as to whether the AI Act is going to stifle innovation or not. I would really keep an eye on the guidance that is coming out in the next 2 or 3 years that could either soften or sort of clarify obligations in the act, and the clarification could make the obligations less burdensome. Equally, the EU is permitted to issue delegated legislation to supplement some of these areas. Those could, expand or clarify the AI Act in ways that are unhelpful from an innovation perspective. So, on that topic, I would say, watch the space.
Hmm. Yeah. What's your view on the recent Draghi report?
Yeah, so I think the Draghi report raises some pretty important points. So, as we all know, the report suggests that certain key EU regulations like the GDPR have had an adverse impact on innovation and competition in the EU. Now, I'm not an expert to assess whether the Draghi report is accurate or inaccurate in that aspect. All I would say is that it does raise some important questions, and certainly as regulators and the European Commission think about delegated legislation and guidance under the AI Act, I think they would be well served by keeping at least one eye on what a former Prime Minister Draghi and his colleagues have set out in that report.
Yeah, makes sense. Now, one of the value propositions that is driving the EU AI Act is that it addresses a lot of it fosters ethical standards, it fosters creation of ethical AI systems. So, help us understand what are the key ethical concerns that the EU AI Act addresses, and how can businesses ensure that they are meeting these ethical standards as well as everything else?
Sure. So the issue of data ethics and AI ethics has been around sort of a few years now, and the underlying principle is if something is potentially lawful but possibly awful, should a company still go ahead and do it? So should sort of things that are lawful but awful still be pursued? Now, that sounds like a very kind of easy way to summarize it, but actually it has multiple layers of complexity, because what's awful is, in the eye of the beholder. And and we often see this in kind of freedom of speech and online content moderation space as well. So I think I would say that as companies design their AI Act compliance program, depending on the scale and complexity of the company involved, they may also want to think about having an ethicist or a ethics committee on the side that evaluates things like the potential for bias or potential for discrimination, or the potential for treating vulnerable individuals in a less than acceptable way. So even if those are possibly lawful, should a company pursue that technology or that business model because of these potential and negative social impacts? So those could have in the end adverse reputational costs, and sort of lead to a business impact, even if on paper it's lawful. So depending on the business and the product, company may want to create a parallel data ethics or AI ethics governance framework as well.
Yeah, yeah, makes sense. Um, how do you see the EU AI Act influencing the AI regulation landscape in other regions as well? Europe is typically seen as the leader when it comes to regulation, right? It's more cautious than elsewhere in the world. So, how do you see this particular act influencing other parts of the world when it comes to regulation? And could we be moving towards a more global standard for AI governance? Because AI knows no boundaries, right? Algorithms don't respect boundaries. So, could this pave the way for a more global standard also?
Um, that's a great question, Artie. And I'd say that as we discussed at the start, the AI Act is the first of its kind. It's the world's first, comprehensive AI-focused legislation, and it could well serve as a template for other AI laws elsewhere in the world. So the analogy would be the GDPR, which has served as a template for privacy laws, pretty much around the world. Now, but I think on the AI Act front, it's still an open question because one actually does not know how well received the AI Act will be in the coming few years.
Mhm.
Now, the GDPR had a predecessor, and so there was a 20-year run in sort of like leading up to the GDPR. So many of the concepts in the GDPR had been previewed over a 20-year period. And so when the GDPR came along, yes, it was a jump, but it was an incremental jump.
Right.
And so that allowed it to really kind of be accepted in other parts of the world. The AI Act is really, it has no real predecessor. And so whether or not it's going to have the same take up elsewhere is going to turn on how things are received, how the act is modified, supplemented by guidance in the next 2 or 3 years. So I think the question is an open one.
Yeah, yeah, good one. So Vishnu, we are coming to the end of the interview, and one question I like to ask all my guests is, as we move beyond the algorithm, what should leaders and at executive tables and in boardrooms be talking about, but are not?
Um, Absolutely. So I think on AI, I think the number one thing I would say is that boards need to get different parts of their business working as closely as they possibly can. So the design team can't be working independent of the legal team. The legal team can't be working independent of the marketing and sales team because the AI in general has brings together so many topics, right? It's the AI Act itself is so technology intensive, technology dependent. So for anyone to interpret the act meaningfully, one needs to have a technologist in the room. Equally, like a technologist just developing AI technology, but being unaware of the legal framework, the ethical framework, that could end up in a dead end. So technology person has a great idea for technology, but it ends up being a prohibited AI system under the Act. good luck with like explaining to your board how you expended millions of dollars on it for it to be basically mothballed for life.
Right. So I like that soundbite a lot, that AI basically enforces breaking down of silos, right? AI brings teams together and forces teams to work together. Vishnu Shankar, thank you so much for your time, for your insights, for really unpacking this very complex topic for us today. Thank you.
It's my pleasure. Thanks, Aarti.